Hi there, I'm Christine Van Geyn, and this is a special episode of the Canadian Constitution Foundation's Freedom Update. I am in British Columbia, I'm in Vancouver, for our hearing where we're going to be challenging the BC government for their vaccine passport policy in this province. I just arrived in the city, and our hearing is going to be taking place on April 19th and 20th. So I thought I'd film a special episode of the Freedom Update from here and in Vancouver and tell you a bit about the case and what we're going to be arguing. I have a few previous episodes of the Freedom Update about this case, but I want to get you all up to speed on everything that's been happening. Can't wait to tell you about it. If you're new here, welcome. Just as a little bit of background, my name is Christine and I'm the Litigation Director for the Canadian Constitution Foundation, a Canadian legal charity that fights for fundamental freedoms in Canada in the courts of law, which is what we're going to be doing this week in Vancouver, and in public opinion. I upload regular videos to YouTube about our ongoing cases, like this case in Vancouver, as well as other interesting developments about constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. And you can also ring that notification bell below, and that way you'll be sure to never miss one of these updates. Please also remember that my videos are not legal advice. If you have your own legal question or problem, please consult your own lawyer. So as I mentioned, I've already filmed a few videos outlining the background of our case in British Columbia challenging the province's vaccine passport policy. You can watch those old videos if you want to get up to speed on everything. But basically, we are challenging the policy because British Columbia has failed to create a workable system of medical exemptions for people who can't be vaccinated. This is a violation of our charter protected right to equal protection under the law and the right not to be discriminated against on the basis of disability. So you can watch those previous videos, but just as a little bit of a background, if you haven't had a chance to watch them yet, we are working with 3 individuals who are directly impacted by this unconstitutional policy in British Columbia. The first is a teenage girl named Erica who developed heart inflammation after she got her first dose of a COVID vaccine, and it's made her ineligible for a second dose. But she isn't eligible for a blanket exemption from the vaccine passport policy that was in force in British Columbia. The second person we're working with is a woman named Sharon who developed severe nerve damage following her first dose of a COVID vaccine. It's a very rare side effect, but it has left her arm partially paralyzed. She then got pregnant after developing this paralysis, and her neurologist advised her not to get a second dose due to the risk of further nerve damage, including nerve damage that could have impacted her unborn baby. Now she's had her baby, and while the vaccine passport policy was in force in British Columbia, she wasn't able to go to mommy-baby classes at her local community center and was otherwise excluded as a new disabled mother from all kinds of activities. The third person we're working with is a woman named Veronica who has complex and overlapping disabilities. She's undergone about 15 surgeries. She's contraindicated for many different medications, and due to her really complex medical situation and the lack of information about how the COVID vaccine might interact in the body of a person like hers with so many complex health problems, and because of her past drug reactions, she declined to get vaccinated at all because of her heightened risk to an adverse reaction. But the problem with Veronica is that she relies on access to her local swimming pool for the many hours a week that she does of swim therapy. That's her main source of mobility because of her mobility impairments. She does a lot of swim therapy in order to manage her disability. And because of the vaccine passport policy, she was unable to go to swim therapy, which had other terrible impacts on her life, including the need to increase doses of nerve blocking injections that she needs to get. So you'd think that it would be pretty clear-cut and simple for these 3 people to get medical exemptions from the vaccine passport policy in British Columbia, but it isn't. While at first the BC government said no medical exemptions at all would be accommodated, they did eventually cave and say, yes, they would provide a process for obtaining medical exemptions, but in practice, they really aren't obtainable, even for these three people with really compelling stories. Now, before I get too far into the case, I want to address a question I get asked a lot, which is why not challenge the whole regime? And at the CCF, we do take issue with the vaccine passport policy in principle in its entirety. But to answer the question of why we brought this particular more narrow challenge, well, we like to take cases with a good chance of success. And the rights at play in this case are in really sharp contrast. It's really easy to see how wrong it is for the government to fail to accommodate these people in our case and others who are in similar situations. Also, remember that the outcome, if we are successful, is that the entire regime gets struck down. The government will have an opportunity to reenact the vaccine passport policy in a constitutionally compliant manner, but a victory in striking down the whole regime will make the government take serious pause in how they would proceed should they try to rebuild a different vaccine passport policy. If we win in this case, it will also create meaningful judicial guidance for other cases in the future. And this is a really good chance to get some legal principles set out on the limits of policies like vaccine passports. There really isn't going to be a better opportunity than this one. Sorry if you heard all that honking. I'm in this hotel in Vancouver, and the city can be a little bit more noisy than my usual office in Toronto. So another question you might be wondering is why this challenge is still going ahead now that the BC government has ended the vaccine passport policy. Well, the fact is that we need to proceed because the government has said that they may bring back this policy in the fall if case rates and hospitalizations rise again. And they've given no indication at all that they would amend the policy to make it less discriminatory. So because the policy has now ended, the government is trying to stop us from getting this hearing. They're claiming mootness. They're saying that the case is moot because the policy is no longer in effect. But a really big problem with the government's claim of mootness is that it makes a policy like this evasive of review. The court should really exercise its discretion in this case to hear it. Otherwise, the government will be able to evade review entirely. The nature of matters like this, legislating during a pandemic, means disputes will almost always be moot by the time it gets to a hearing. We've been working on this case since the summer of 2021, and we're finally having the hearing now in April of 2022. The government can't avoid judicial scrutiny by claiming that the matter is moot. In crisis issues like pandemics, the crisis is often over before the court can even hear the case. So they can't claim mootness just because the process of review takes so long. The nature of pandemics and the public health measures that are enacted in response to them is that emergency orders change really quickly. Too quickly for a constitutional challenge to get before a court before the order has been repealed or even just changed. If the court refuses to hear the case, it will basically be making these charter breaches immune from judicial review in the context of crisis situations. And this is especially problematic where there are really strong indications, the government is even saying so themselves, that the entire scheme may be used again in the future. Only a few months away in the fall, the government said so themselves. At the very same press conference on March 10th, where Dr. Henry announced the repeal of the vaccine passport policy, she acknowledged that a new vaccine passport program may be needed to be re-implemented in the fall if new variants emerge. This is all consistent with the fact that throughout the pandemic, governments across Canada have repeatedly revoked and reinstated public health orders in response to cyclical reductions and increases in case counts and hospitalizations. And often we see that these reinstated orders are completely indistinguishable from the earlier orders. So it's entirely likely that the orders we are challenging, well, identical ones, could once again be brought in and violate once again the rights of the people in our case, Erica, Sharon, and Veronica, as well as other people in similar situations. And since the BC government's position is that there's nothing wrong with the vaccine passport policy anyway, the policy that doesn't accommodate Erica, Sharon, or Veronica and their medical conditions, well, any return of the vaccine passport policy will most likely be the same and continue to violate their rights. There will never be a better opportunity than this one for the court to give guidance on the constitutional requirements for medical exemptions from a provincial vaccine passport program. It's extremely important for this case to be heard, even if the policy is no longer in force for now. So let me get to what the hearing is going to be about. The case has really crystallized into 3 questions of fact. First, did the vaccine passport policy create a closed list system where those people with unlisted disabilities, like Sharon and Veronica, are not eligible for medical exemptions? Second, even if the vaccine passport policy didn't create a closed list system on paper, was the exemption regime really illusory to the 3 people in our case because of the government's public statements? Things like there are no exemptions, combined with statements by the College of Physicians that caused doctors to believe that there would be professional consequences if they provided an exemption letter for an unlisted condition. And third, even if the 3 people in our case could have applied for an exemption, did the policy limit that to an activity-by-activity exemption? Under the government orders, there was no option to apply for a generalized exemption. You need to apply every time you had an activity in mind. So for the government to win in this case, the court needs to answer all 3 of those questions no. But they won't succeed. There's clearly a closed list system for medical exemptions in British Columbia. The BC government, including the Premier, Minister of Health, and Dr. Henry, actually all stated there would be no medical or religious exemptions at all at the beginning. And they've created a system where in practice that is true. On September 9th, after we at the CCF wrote to the BC government saying that the failure to create medical exemptions is unconstitutional, well, they announced that they would create a medical exemption process for what they called rare medical conditions, but this was all illusory. The vaccine passport program doesn't grant treating physicians the power to write letters that can exempt a patient from their requirements. Instead, the Public Health Office reserved the sole right to approve exemption requests, essentially creating a public health veto power over the clinical judgment of doctors. They inserted themselves into the private relationship between doctor and patient. This procedure was created on September 10th, but by November 12th, the Public Health Office changed their mind. They quashed all previous submitted requests for medical exemptions and refused to receive any further requests except for those on a closed list. This is the closed list that I've been talking about. This was a list created by the government in a document called Public Guidelines for Request for Reconsideration Exemption Process. This document was issued on November 12th, the same day. The document had literal checkboxes that needed to be ticked with the medical condition that the patient has that qualified them for an exemption, and Veronica and Sharon's conditions weren't listed. Erica's condition, pericarditis caused by the first dose of a COVID vaccine, it is on that closed list. It did have a checkbox. But Erica's only eligible to apply on an activity-by-activity basis. The process in place doesn't permit the granting of a blanket exemption. Now, in response to our lawsuit, the government wrote a letter saying that they will, in fact, grant blanket exemptions and even consider conditions not on this closed tick box list, even though the mandatory form on the public health orders don't permit this. So this is a totally absurd argument for the government to be making. An unconstitutional public health order can't be saved by a letter from the government telling a member of the public that they can ignore the wording of a validly enacted order and that the government will proceed contrary to the wording of that order. If the government's view is that the wording of their order has created a barrier for people with disabilities, they need to amend that order. They need to concede in this case that their order was drafted in an unconstitutional manner. The government can't escape a finding of unconstitutionality by permitting things in practice which their own orders and mandatory forms prohibit. So this is what we're going to be arguing in court on April 19th and 20th. The hearing is in person in Vancouver. So unfortunately, there isn't a live stream in this case. But if you follow me on Twitter at @CVanGeyn, I'll be tweeting out updates, and I'll also try to upload more videos describing how the day goes by. If you sign up for our email updates, you'll also be able to stay up to date about how the hearing proceeds and about all our other ongoing cases. You can sign up for those at the ccf.ca/freedom updates. Okay, well, that's all for this update. Wish us luck in court this week. We are really excited, and I really am feeling really optimistic about this case. So thanks for watching, and let's keep fighting for freedom in Canada.